Okay, we're going to go ahead and get started. It's always a process getting everyone fed during a lunchtime panel, but thank you so much for joining us. As societies transition from authoritarian regimes to liberal democracies, lawyers around the world are seeking to transform law from a means of social control to an instrument for the common good. Here in the US, the public interest lawyering movement is arguably going through middle age crisis, perhaps, and is looking for new sources of inspiration and new strategies for impact. So the Levin Center has launched a new international public interest initiative, and the goal is to leverage the resources of the law school to support public interest attorneys seeking to build more just societies, as well as connect students and alumni to educational opportunities and careers in the field of international public interest lawyering. My role today is to introduce Chris, who's going to start us off with some opening remarks, and then turn over to Professor Jenny Martinez to moderate. So it is really a distinct pleasure and honor to introduce Chris Stone, who is the president of Open Society Foundation. I've known Chris for about 12 years now, since I was a brand new program officer at the Ford Foundation, and he was the director of the Vera Institute of Justice at that time. In that role, I was sometimes skeptical of the value of foreign experts that would come parachuting in to a pretty complex context. But Chris had this ability to land in China, to step into a conversation with a very diverse group of stakeholders working on criminal justice, who had their own axe to grind and complex interpersonal dynamics that we could only begin to understand. And somehow he could cut through all of the noise to the heart of the issue and find a way to put together a blueprint for how everyone could work together in the interests of truth and justice. In his new role as the president of the Open Society Foundation, he is leading a crucial effort to build vibrant and tolerant democracies around the world whose governments are accountable to their citizens. I know that there are activists around the world that are very hopeful about what the foundation will be able to accomplish with Chris at the helm. Thank you.
The world was so much simpler when we were just trying to work in China. It's a great pleasure to be here. And let me just offer a couple of remarks. The question we were asked to address, I guess, on this panel is, what is the power of human rights for transnational and social movements? I just love the question. What is the power of human rights? I think the power of human rights is a great phrase because it is, these struggles are just as much about power as they are about rights. And I think understanding where the power in rights lies is something I actually I struggle a lot with and try to sort through in each place that I find myself working. So I'm looking forward to what we're going to learn together in the next hour about that. So let me just offer some opening reflections on this. I hope we'll develop them over the next hour together. So what's the power of human rights for transnational and social movements? So you want social change, you want geopolitical change. What power can you find in human rights? So if you're here in California right now, trying to defeat the death penalty through Proposition 34, big human rights struggle. Look around. Power of human rights, not so much. Right? There's if you look at the ads, you look at the campaign, the death penalty, if it is defeated in California, it's not going to be because of a campaign focused on human rights. It's going to be a campaign focused on cost, on efficiency, on whether it works or not, as if it worked, maybe that would be okay, but it doesn't work. It's very expensive. The slogan is not the death penalty is wrong. The slogan is the death penalty is broken. So at least in that context, maybe we conclude the power of human rights is not so great if you're on a social change agenda. Now there are counterexamples, of course. One of the ones most looked to these days is the Arab Spring and the slogan in Tahrir Square of bread, justice, and dignity. And it's the last of those words that resonates as a human rights claim. Bread riots, of course, are as old as bread. The bread riots of the Middle Ages certainly are well documented. They often they lead to all sorts of things, but rarely to social change. But if you combine, as Barrington Moore once wrote a long treatise on, if you combine the lack of bread with the lack of justice, then you have a revolutionary moment. And a lot of the great revolutions of history are traced back to essentially bread riots combined with claims of injustice that rally people to real change. Whether it's the women of Petrograd in February 1917, who start a bread riot after standing in queues for bread that lasted usually all day and sometimes several days. It became a Russian Revolution, where they think back to the French Revolution and issues of bread and justice there. But the combination of bread and justice has been joined in recent years with the claim of dignity, or we might say of human rights as well. I actually one of the places I like to look for the emotion behind this is a play, Peter Weiss's play from 1963, where the inmates of the asylum of Charenton, in a performance organized by the Marquis de Sade, reenact the years of the French Revolution from 1793 to 1804, and the slogan, the chorus that's sung in that, I'm not going to sing it for you, don't worry. The chorus that's sung in that play is Marat, we're poor, the poor stay poor. Marat, don't make us wait anymore. We want our rights and we don't care how. We want our revolution now. Human rights as the aim, as the goal, by any means necessary. There's another way in which I think human rights has a power for transnational and social movements, even for the death penalty in California. And that is not as the goal, not as the reason, not as the argument for social change, but as a process. Human rights not as the goal, but as a process of change. Not we want our rights and we don't care how, but we want something, we want dignity, but there's a process that human rights embodies that can guide us in that struggle. It is, in a sense, thinking of human rights as a method of moving from human dignity, universal claims of human dignity, to concrete, legally enforceable human rights. And if that's our struggle, if what social movement, social change, transnational change involves is the making into law, making into rights of claims for human dignity, there's a process about that. In particular, there are competing processes, of course, in the human rights movement. But I've always been inspired by Abdullah Nahim's argument that you can't create rights, you can't make that process work of going from human dignity to legally enforceable human rights by declaring them to exist. Now, of course, he's playing on the words of the Universal Declaration of Human Rights and arguing that you don't make a right doesn't become a right because it's been declared to be such. His argument is that rights become rights when you claim them, not declare them. And that has been, I think, long a inspiration for me. So what does that process look like? What does it mean to claim rights effectively? To claim them effectively, your claim has to be heard. Your voice has to be heard. Your power has to be felt. And there are all sorts of obstacles to people's claiming of rights and claiming of their power. And in the point is you've got to move those obstacles away. You've got to allow claims to be heard. And then there's a process of discourse or discussion, a debate, in which those claims become law. That process, inclusion, claim, inclusion, discourse, law, that is a method of human rights work that I think applies pretty much anywhere. But it warns us, I think, against trying to advance human rights on behalf of others who aren't claiming them, and instead trust the claims that people make for rights, even if they are in different language, different words, different concepts than we might imagine ours to be. It is a gradual, iterative, tentative process of rights formation rather than a momentary, revolutionary moment of creating rights instantly out of dignity. The last thing I just say about it is I think come back to the point about power with which I started. Hannah Arendt defines power in contrast to violence. Power, she says, is about discourse. It's about people coming together. The power exists only among people, only between human beings in a conversation, discourse in which you can create social movement in a positive way. Violence, in that sense, is the antithesis of power. It's an interesting conception, a different one than we often think about. Violence is destructive, but power, she says, actually has to be recreated in every moment. It's really fleeting. People have to come together, you create a power, and then if you don't maintain that discourse, if you don't maintain a kind of solidarity, it will dissipate quickly. And so the practice of power in a process of human rights creation, of moving from dignity to rights through inclusion, through claims, through discourse, and finally through law, is the power of human rights, at least for me. And it's a way, I think it's a way of thinking about our struggle for human rights as one about inclusion, about voice, and about power, whatever the context, even in California. Thanks very much.
Thanks, Chris, for setting what I think is a wonderful stage for the discussion we're going to have over the course of the next hour. We have with us some very distinguished panelists with wide experience in working for social change, for justice, and sometimes using the concept of human rights as a key component of those efforts. I want to thank our panelists, both on this panel and the other panels during this conference, for traveling from so far away to be with us here, and I hope that we'll have a very productive discussion. I was going to introduce our panelists, but in the interest of time, I'll note that their biographies are in the program here, and I think we'll drive straight into the discussion. Each of the panelists is going to give some brief remarks on the theme of the panel, the power of human rights ideas for transnational and local social movements, and then we'll try to open up a dialogue among the panel and with those in the audience. So with that, I'll turn it over to Viviana.
Thank you so much, Jenny, and thank you. I want to thank the organizers of this conference for the distinct pleasure of being back at Stanford, where I studied many years ago, and also to be surrounded by so many friends and colleagues. There are many aspects that we could delve into because the question that has been posed to us is really fascinating. And I think part of the answer to this question could take a whole semester of exploring different facets of the discussion. I do believe that part of the power of human rights lies on the types of discussions that you need to have, and that is oftentimes marked by historical context, political context, and also normative frameworks. And so part of the remarks that I will be giving now are a way of initiating this discussion, but also are very much permeated by my own experience as a litigator in Latin America, working with social movements and human rights victims in litigation before the Inter-American Commission and the Inter-American Court on Human Rights. And I will start with a story that is very dear to me of the Sarayaku peoples of Ecuador. It's an indigenous community in the Ecuadorian Amazon that has fought since 2002 against the government and an oil company to preserve the integrity of its territory and its rights to manage their own territory. And in the course of preparing for the litigation before the Inter-American Court, a colleague of mine and I went to the Ecuadorian Amazon to discuss with the whole assembly of the peoples of Sarayaku part of the strategies that would follow. And we also got a chance to talk to some of the leaders and the wise people of the community and the young people in the community about the history and why is it that they were choosing this path. And here comes the story of Franco Viteri, who's one of the political leaders, and he said to us, while walking in the middle of a path in the jungle, that he had been struck not only by his commitment to the mystical beliefs on the beings that rule the Amazonian jungle and that inspire him, and the history of other indigenous peoples of Ecuador in dealing with oil companies, but also by Gandhi and Martin Luther King, and how that had been important to him in devising a whole a strategy and debating with the community about how to deal with the oil company and the government, and using a nonviolent path to confronting a very uneven, really, fight for control over their territory. And so here comes Franco explaining why human rights and rights was important to their fight. And it also showed me how some of these ideas and concepts and readings and stories can also be transformed and transformative in very powerful ways, in a dynamic that is really about reprocessing and reinventing part of what Gandhi and King have said and what the content of human rights is. In the context of the case, we litigated demanding respect for the right to land, to culture, to identity, and also to the right to be consulted in any matter relating to their land or the enjoyment of their rights. And finally, the Inter-American Court came down with a decision granting them those rights and framing for the first time an autonomous right to consultation and a right to identity that was very much shaped by their own argumentation before the court and the powerful evidence that was behind the litigation that they had devised as peoples. So what was important in part of this story is that their claims, their collective claims, were not only phrased as just social claims, but they were claimed as human rights, as the defense of fundamental human rights. And that allowed them to make connections and bridges to different ideas and groups nationally and internationally. The idea that it's not only a right and it's not only a legal claim, but it's a human rights claim resounded in the fundamental nature of their fight, and also the parallels between their fight and the fights of other groups domestically. But it also resounded with other indigenous peoples in our region and abroad, as you can see, for example, with the impact that some of that litigation has had in Africa. If you look at the Saramaka case and how the Endorai case against Kenya that also drew from the standards of the court. So there are ripples of these discussions of framing things as human rights claims that when they are backed by norms but also by accountability mechanisms, they can be really powerful in creating social change and in creating the alliances that allow you to preserve those rights. I have to say that also this dynamic that is so well illustrated by the advocacy and the litigation that was done domestically and internationally on the Sarayaku is also not a static dynamic. I think human rights concepts are also transformed by these fights and are expanded by these fights. And I think part of the history in our region of the fights of the women's rights movement with the Maria da Peña case and with women's rights as human rights and the definition of the scope of violence and state responsibility and things like that illustrate as well that dynamic. And that dynamic is also illustrated, or part of those, that's Franco Vitteri, the guy, the wise guy. And this is a very powerful women leader of Sarayaku. But they can also change human rights law, and they can change the fights in very provocative and effective ways. And I think one of the experiences that we'll probably discuss more profoundly tomorrow is the whole discussion on issues of trust, truth, justice, and accountability in Latin America, where also these dynamics of creating and framing rights and understanding the scope of rights and using domestic and international mechanisms has been key to human rights and to many fights for dignity in our region. So, thank you.
Thanks very much. We'll turn next to Innocent.
Thank you. Good afternoon, everyone. I welcome the opportunity to be here. When I got the topic for this section, it did raise a number of questions in my mind, which I'm going to start with before sharing a little about our experience in Nigeria as far as the issue of the influence of human rights in social movement, whether the local or international levels are concerned. For me, the first question is that the question itself is debatable in the sense that between human rights as an idea and social movement as a process, which one is dependent, influential, or powerful to the work of the elder? In some way, brings forth the issue of chicken and egg. Because on the one hand, yes, the leaders of social movements their choices and the actions they take depend on their ideas of human rights. But on the other hand, human rights need the vehicle which social movements provide in order to get popularized in the mass, accepted by the mass, and make it, viewpoints that they are willing to lay their lives for. Because in many places, some of these ideas, as you very well know, have led to death. So which one is more influential or powerful than the other is something we need to look at. And if you understand it in that way, you begin to realize that they are perhaps more symbiotic. They depend on each other in order to get advanced. In other words, you can't single out that this one is more influential to the work of the other. Then the other question is, are all social movements influenced by the idea of rights? Is it possible to have movements that are popular in certain societies but not driven by any notion of rights? They can be driven by claiming privileges that have been there in religiously divided societies or racially divided societies. So the assumption that all social movements are influenced by rights, which is implicit in the questions that we are asked to answer, is itself contestable. Then the third question for me is, if you believe that, yes, for some social movements, that the idea of human rights are indeed powerful and influential, then the question that arises is that at what stage is this influence and powerful more relevant? If you take the literature compartmentalization of the stages in the evolution and eventual decline of social movement, to begin with emergence, when a few people raise issues about what they observe in their environment, either through letters to the editor, occasional publications, and all that, trying to get the rest of the population to see an issue as a problem. In other words, trying to problematize a situation that everybody comes, passes, and take it as something that is normal. So is it at this stage that human rights becomes very influential? Or is it the next stage, if you like, coalescence of ideas, when forces that agree on an issue come together to fight it and begin to make demand on authorities, begin to identify who the enemy in quote is, and begin to focus the energies of everybody in the populace to fight it? Is it at this stage that the idea and influence of human rights become critical? Then the other one is the third stage. Is it at the level of bureaucratization, where everybody has been exhausted on the street and begin to realize, like the early Christian community, that the second coming of Christ is not as imminent as they thought it was, that you needed to set up institutions for the establishment of the church on earth. And then you begin to see writings of Paul from earlier stage when he says, those who are married, live as if you are not married, to his later writings in Timothy, where he said, let the bishop be the husband of one wife. In other words, he has started setting up the institutions of church as something that has come to stay for a longer time and therefore requires bureaucracy. It is at this stage. Or is it at the stage of decline, either because they have succeeded in achieving their aim, or they are repressed brutally that they can no longer continue, or they are co-opted by the government in power? All these are open for discussion. But for me, context is everything, and context determines what happens. And our own context in Nigeria was that by early 80s, Nigeria practically has gone into receivership, presided over by IMF and World Bank. Overnight, people who had depended on the state for education, for social welfare, because Nigeria needed a loan from IMF and was told that you have to stop giving free education, you have to stop doing this. And overnight, people started, agitating. And this was a circumstance in which a lot of people who were not listening to those who were agitating for one thing or the other began to pay attention. And it was also a time when because of the collapse of socialism in Soviet Union and Eastern Europe, all the student leaders and working class intellectuals who were previously absorbed by the international working class movement are now available for jobs. And the emerging human rights movement provided the platform that engaged all of them. Then the other thing is also the egregious violations of rights, because by 1985, we had a military government that came in and promised that it will respect rights. People began to have consciousness about rights, and along the line, the government did not do so. We should also not forget that within this period, we had the emergence of donor funding that are willing to fund groups that are interested in defending individual rights and private sector-led development. So this context created a convergence of forces that would ordinarily have worked differently into agitation for an end to military government. And at that point, groups that were previously canvassing for gender rights, canvassing for children's rights, for all kinds of issues, realized that the central obstacle in their way is this government that is military, that does not respect rights, and does not obviously allow people to participate in government. And it was through that understanding that a lot of the struggles of the 90s in Nigeria were waged. And if we take the discussion a little bit to the larger context of this conversation, which is the women's rights movement, at what point do you insist that these ideas be infused into the process? And we have a vast literature out there that says, oh, it has at the outset, you really need to infuse this. If you don't, you will have a repeat of the Iranian experience where they were told to wait until after the revolution and the discussions about how to respect human rights. I think from my own experience, it's not that academic because everything depends on the forces that are pushing for women's rights. How influential are they within the larger social movement? And we have grown to understand that when you are fighting for something, nothing is given. You have to negotiate for it, and your ability to negotiate effectively depends on your ability to demonstrate that you have the strength to force the other forces to listen to you. So what I'm saying at the end of the day is that nothing is given. We have to really interrogate all of it. And for me, context is everything.
Thanks very much. Janet, over to you.
Thank you. It was already becoming difficult after Chris started to think of what additional things to say, but now it's far worse. So I think that for me, there are a couple of points. Human rights as a concept has a distinction of having both a transnational as well as a local resonance. So I think that the fact that that is a term that is used within the international environment, within the local environment, does not, we cannot presume that it means the same in both areas. We cannot presume that there's something completely set and something definitive that is understood at all times. And that in itself means that it's a vehicle for, I think, important mobilization and discussion. It's certainly also a vehicle for levels of international as well as local solidarity. So that, to me, is one of its powers. The second thing is that I think that it's associated, when we talk about human rights, we associate the notion of human rights with struggle and the demand for something. And I think it's important for us to recognize that that means that the movements for human rights are usually movements that come together because they're against. And that is not this, and so the leap from being against to being for, and what is it that you are for, is quite a big leap. And so often there is a lot more discussion and mobilization and energy and discourse when you're against than when you have the much greater task, in my view. I'm sure that the South African example is probably a very good example. You have the much greater challenge of really implementing what it is that you've been fighting for. So I think that that question of then looking at the power of human rights for transnational and local social movements, I think is the fact that it was that the term social movement as opposed to organization was used, I think was a very clever phrasing of the question, because it seems to me that when you're looking at a social movement, you tend to think of something that is a lot more diffuse, something that is a lot more responsive, often something that mutates, something that starts as being single issue driven, picks up a few other issues along the way, and often forgets as to how it first came about. So that notion of the fluidity of a social movement, I think is really important, because it seems to me that the power of human rights as concept is something that is not as strong or has only got provides a limited lever when you're talking about organization. Because organization, firstly, can calcify a lot more quickly than one ever thinks or hopes can happen. But secondly, organization then tends to have to engage in some of the challenges of delivery. The third issue that I thought would be quite important, and it builds on things that have been said by speakers before, where Chris was talking about human rights providing a framework within which to struggle, and part of that struggle being around questions of interpretation, prioritization, and so on. But I think that what really is a challenge for us to think about is what happens when human rights becomes law. So now you're not necessarily struggling for human rights. Human rights are there. But the delivery question is a whole bunch of steps away. And if you look at this question of delivery and the realization of rights, and that's not exclusively in terms of socioeconomic rights, it's very much around all rights. Civil rights have many of the same challenges depending on how one tends to engage with them and understand them. But if you look at the realization of rights, you're seeing an element of infinity, particularly if, as you have within the South African Constitution, the notion that the realizations of those rights is a progressive thing. It's something that's going to not be able to happen instantaneously. It's something that will happen over time. And over time, there are going to be so many changes in the social and economic and international environment that the nature and the content of the right itself will change, let alone the issue of the realization. So this notion of infinity becomes a huge challenge, and it becomes a challenge particularly because people have got struggle fatigue. And particularly in the international environment, there's lots of struggle fatigue. And so when you get something that just feels too big, too amorphous, and actually going to be so perpetually energy draining, the best thing to do is to house it in an organization. Okay? And then the minute you house it in an organization, you take away all that element of dynamism. And if you look at this notion of international solidarity, that's exactly where you can see it best. You know, the notion of international solidarity around human rights campaign, it is so deadly boring for the most part. I tell you, it's just, you just want to yawn, okay? Now, it didn't used to be quite as bad. And then there were a whole lot of institutions and institutionalization of it. And so I think that that's, just something to bear in mind, that the realization of rights and their progressive realization is all well and good, but people can get quite tired. And then the last point that I wanted to make is that it's really important when we look at the notion of human rights to recognize that you have to bring a local content into those rights. Because otherwise the whole question of legitimacy, firstly, is a huge problem. But more importantly is you begin to generalize in a way that those rights can also become relatively meaningless within domestic, national contexts. And so what's the process to do that? And what are the issues that you need to tackle? And very often, some of those issues, particularly when you're talking around gender, are the much more intractable issues. In our situation in South Africa, part and parcel of our struggle was the issue of women's rights and the realization of equality for women, and including questions of insisting on measures to affirm women in a whole range of ways. Notwithstanding that, we still have swathes of customary practice that where there are attempts to perpetuate patriarchy in its most vile form. We still don't engage sufficiently within the religious context around what are the aspects of religion that are manipulated by the patriarchs of religion to suit an agenda that undermines equality for women, and what is not, and how does one shift that? How does one move that? So all of that is about localizing the content of international rights.
Thank you. Over to you, Jim.
Thanks, Jenny. When I first saw the question, I knew there was a right answer, but that I just couldn't figure it out. And now I know there are 4 right answers, and I still can't figure them out. So let me give you the wrong answer, at least one. The power of human rights ideas for transnational and local social movements is distinctly mixed. On the one hand, in some contexts, rights, ideas, and language have been powerful agents of change. This was true for many participants in the civil rights struggle in this country in the 40s and 50s and 60s. Malcolm X, of course, famously said, "Civil rights means you're asking Uncle Sam to treat you right. Human rights are something you were born with." It's also been true, of course, for marginalized peoples around the world. In many different contexts, rights discourse and imagery can be a powerful spark to mobilization and self-awareness. For citizens who seek information from their government about environmental abuse, to non-citizens and stateless persons who simply want to be able to work or reside legally or get health care. Why are rights so attractive to some? We've heard a number of reasons. There are others. Let me just highlight 4. First, rights enable those who are victimized to universalize their claims, to show both to themselves and to others that they're not alone, that they share a condition with many, and that their struggle for vindication is linked to that of others, often far away. A second attraction of rights is that in the view of some, they transcend politics. One of the, of course, the crowning organizations of the modern human rights movement is Amnesty International. And back in the early 1960s, its founder, Peter Berenson, explained that the organization was, quote, non-political, non-sectarian, international, and it has a purpose to find a common base on which the idealists of the world can come together and cooperate. Others have put this in different ways. Soviet scientist Yuri Orlov saw in human rights an ethics common to all humanity. Still others have underscored the value of rights in reaching beyond the politics of the everyday. A third feature of rights, and we've heard about this today, is that often they're concretized in law. And thus, rights language may give the claimant, the right holder, the power of legal coercion. So rights are not just dreams and hopes. Backed up by the power of law, they can be concrete and real. And fourth, the link between rights and law serves a tactical aim as well. Laws often embody official pledges to uphold rights. A government's very pretense to respect rights through ratification of treaties or the adoption of legislation invites dissidents to respond, as Václav Havel famously said, through persistent and never-ending appeal to the laws. The law, in short, opens up avenues of advocacy in the gap between what is and what ought to be. So rights give us a great deal. But rights are not always and everywhere the chosen language of activism. First, in some contexts, rights language may not offer the most powerful arguments for change, again, as we have heard. So, just to take an example, for victims of pretrial detention, a global population of several million, the most persuasive arguments for change may not be that such persons have human rights, though of course they do, but rather that by contracting and spreading potentially fatal diseases, they pose a health risk to themselves and others inside and outside prison walls, or that it's costly to detain people, or that by over-incarcerating thousands and thousands of people who are not charged with violent crimes and putting them together with hardened criminals, you're contributing to recidivism, and you have massive social costs from that. A second point is that the very tools that are thought to give rights meaning, laws and courts, unfortunately, sometimes have little impact in practice. To take one example, over the past 15 years, advocates have made enormous strides in advancing the jurisprudence of European courts with respect to the rights of the Roma people. But the impact of these decisions has yet to be felt on the ground. So despite landmark rulings that have outlawed racial discrimination, most Roma today live in dire poverty, are denied even a basic education, and are subject to severe racial prejudice. So in such circumstances, rights talk, for some, is empty. Third, states are increasingly pushing back against the institutional architecture of human rights. So in the past year, we have witnessed the shutdown of the Southern African Development Community Human Rights Tribunal. We have seen a hostile turn in the Americas against the Inter-American Commission for Human Rights. And we've seen the United Kingdom government, that paragon of human rights for some, lead an effort to intimidate the European Court of Human Rights in the guise of preserving it. A rights backlash is underway. Fourth, opponents of human rights have become remarkably adept at co-opting the language of rights while simultaneously depriving it of substantive content. A current example, the Russian Federation, which is engaged on a crackdown on political freedom at home, is presently spearheading what it calls an effort to enhance the human rights treaty bodies of the United Nations. Though couched in the great in the rhetoric of what Russia calls the great importance it attaches to these treaty bodies, the campaign is apparently aimed at undermining even the relatively weak system that currently exists. And finally, at a more fundamental level, some have argued that it's simply wrong to think that rights are here to stay. On this view, those of us who happen to have lived during the ascendancy of the modern human rights movement, roughly since the late 1970s, too easily replace the actual contingency by which rights assumed a dominant place in global discourse with a false determinism that it had to be that way, and as importantly, that it always will be. To put it another way, on this view, rights are simply one stage in an evolutionary development. And at some point, the tensions and contradictions within the modern rights movement may prove unresolvable. So, adherents may be forced to choose between so-called minimalist or negative rights against violence and humanitarian disaster and more maximalist political visions of equality and justice. And then perhaps another framework may take us beyond the rights era. For these and perhaps other reasons, a number of advocates are consciously choosing language other than rights to frame their narratives of struggle in ways that, though aimed at many of the same goals, consciously seek to be less threatening to those who might otherwise resist. So we have numerous examples, right? Whether the rule of law, legal empowerment of the poor or of other victimized persons, good governance, equity and equality, fairness, justice. In Ukraine, we've been establishing a variety of legal centers that have been established ostensibly to help people protect their rights. But the word rights doesn't appear anywhere. They're called practical advice centers. Seem to be a more effective thing. So just to conclude, I guess, it seems to me that the choice of ideas and language is one that must be suited, and we've heard this as well, to each context. And I think even as we agree that human rights are universal ends, we need to be smarter about rooting our language in context and using rights talk and other forms of talk to achieve what we want to do. Thank you very much.
There's a lot of food for thought in all of these comments. Let me just throw out one topic for discussion among the panel, and then we'll open it to questions from the audience. One of the things that a lot of you touched on was the relationship between the transnational and the local. Vivi talked about the importance of for activists in Ecuador of looking to figures as far-flung as Gandhi and Martin Luther King. Jim talked about the universalization of certain experiences that people might have. Janet talked about the power of the national, but also the need to contextualize or relate to the local. Innocent talked about the context of particular social movements. Thinking about these questions of this kind of attempt in the international law framework to create a kind of universal set of legal rights that would be implemented everywhere, and then the great need for attention to particular contexts, particular societies, the particular rights that are being claimed, and some of the things that Jim talked about in terms of the strategic choice of whether to use a rights framework or some other kind of argument. I wonder if you could reflect on those big questions, the transnational, the local, the choice of a rights framework, in relation to the topic of the symposium, in particular looking at the issue of gender equality and advancing that particular goal through human rights. Is gender a typical example of a human right in this regard, or is it somehow different? Does it exemplify these tensions between the transnational and the local, between the rights framework and other types of frameworks? So I wonder, just going down the panel again, perhaps in the order that we originally spoke, could you talk a little bit about gender equality and how it ties into these issues?
I hate that I have to start every time. But I think in my experience with the women's struggles in Latin America and beyond Latin America, really, the human rights framework has been really very useful, and it has been very powerful. But I also think that it has been changed by the women's rights movement. But that has created a lot of tensions, and I think for women's rights activists or activists on women's issues that did not necessarily initially identify themselves as women's rights activists, the issue of going to rights was sometimes a bit controversial because you're always worried in a social movement that lawyers are going to take over, you know, and with I think with a reason or with multiple reasons that lawyers shouldn't. And so going through these struggles as rights struggles without losing, you know, the spirit, without bureaucratizing or creating an elitist movement was always a discussion. And also the choice of venue, of doing advocacy and trying to change legislation and culture and doing ads or going through litigation and going through pushing hard through litigation, the same struggles was also, it created a tension. Piggybacking or changing the mainstream human rights movement has also been, I think, a strategy of part of the women's rights movement, convincing the traditional human rights movement, which is very sexist, that women's rights are rights, has been a horrible struggle that has not ended at all. And but it also has created tensions, and because obviously including women's rights excludes other sectors from the traditional human rights movement. So I've participated in very funny discussions that are not so funny when you think about them, but keeps me happy just to laugh about them. But things like, well, if we bring women's issues, then we're going to lose the church in issues of violence, and so we cannot lose the Catholic Church as an ally for the main things that are at stake, and so we're not going to embrace anything in the women's rights agenda. So this inclusion and this expansion of the human rights agenda has not been without tension, but I think it has helped. And I also think that the inclusion of many of the issues of the that the women's rights movement has brought into the discussion have also expanded enormously some of our understandings of issues as state responsibility and prevention and affirmative, positive steps for guaranteeing rights and in ways that were unthinkable in the other tradition, I would say. So.
Yeah, thanks. For me, context and strategy of work, again, determines how you use the universal rights, the international organizations in affecting domestic situation. And the issue that comes to mind here is the whole movement against Sharia punishment of women in Nigeria in relation to adultery and all that. It sparked an international movement focusing on it. But those who are working with these women, defending them in court at the time and stage, felt that the international campaign is actually hurting the specific rights of these women. Now, the way they posed their defense for them was not really borrowing extensively on international rights and all that. They looked at Islamic laws and the provisions it made when you are bringing this kind of charges. The typical one is the provision that for you to establish rape, you need to have 4 witnesses who witnessed the event independent of each other. Now this was what won many of the women, including Amina Lawal, freedom from court. So, but if you're looking at the demand side of the work to raise the issue about what women are going through in Nigeria in the context of Islamic law, Sharia law, yes, the international movement, the international human rights law helped a lot. But if you are looking at, again, case-specific interventions or even supply side of justice, because there are also groups working on that, building the capacity of these agencies to incrementally respect this right, putting in their face what UN instruments said about what can actually be counterproductive. Just in the same way that Jim said, you can just look, practical assistance to these people may advance. So context and strategy of work should really define how you engage these issues.
I agreeing with the fact that there's a question of context. Maybe just to say within South Africa, and I think within a number of the international fora of the continent, the question of the international rights framework and women's struggle is an important one when we're looking at the issues of customary law. And I'm moving from the point of departure that actually there are many aspects of customary law that ought to be and are being, but can even more usefully be embedded in the kind of legal systems and the statutory law that we have, just because they depart from frameworks which make a lot of sense. So the one sort of reasonably easy example to appreciate is that within certainly the African customary law context, the notion of ownership of property is really not a particularly important notion. The issue is about the use of property. And in a world where our natural resources are under threat, that notion of use being more important than ownership, I think, has got a lot that we can all learn from. Having said that, there are many issues that, as I mentioned before, go to the root of patriarchy and also and within that cause even further exploitation and marginalization of women than exist in areas that aren't so remote from contact and from mainstream access. And in that regard, the fact of having a human rights framework, and in our situation in South Africa, having that embedded in our constitution, and also being able to use the international framework of CEDAW and so on at the level of the African Union, we have been able to introduce a process of debate and discussion around the question of how one takes from within the customary law framework those things which advance the agenda of humankind and those things which are undermining of that agenda because they prejudice women. And so it has been a very important vehicle for discussion. But I don't think that that will necessarily be for all contexts and for all time.
Jim?
Just a very narrow slice on this. So looking at the relationship between international law of any kind and how it's used in domestic contexts. The United States, of course, is a place that's long been allergic to many forms of international law. That's changing, hopefully, a little bit, but not very fast, I would say. The United Kingdom used to be just about where the U.S. was, but it changed dramatically over the course of 15 years or so after it adopted a Human Rights Act, which internalized a great deal of European law. And it had an impact not just at the legal level, but at the level of advocates and the way people think and act, which was very much internalized. Some norm outside the United Kingdom became part of people's popular discourse, and that became very powerful on all kinds of issues, including but not limited to women's rights. And then if you look within Europe itself, when I moved to Budapest in 1997 and was working in that region for a time, the early part of that period, it would not be very helpful to you to cite to European law, let alone United Nations law of any kind, in domestic courts or even domestic arguments and discussions with government officials in most countries in that region. But that has changed dramatically through the force of advocacy over the course of the last more than a decade. And frankly, in the gender equality area, perhaps more so than in others, certainly more so than in the area of racial discrimination, because in the particular context of that region, women and women's organizations simply have more resources, more education, more capability to make use of the tools of European and international law than many victims of racial discrimination have.
All right, we'll open it to questions from the audience. If you could approach the microphone so that everyone can hear.
Turning it on and asking questions.
Hi, my name is Melinda Lord. I'm a human rights and rule of law practitioner. So listening to the discussion and thinking about words like social movements, human rights movements, the context, and so on, I just wanted to get a little bit feedback on, first of all, individual rights in a non-Western context, because I think a lot of the world doesn't really have that concept of individual rights, and that's why when we go out there and we try to teach this, it's not absorbed very well. And I wanted to ask, at what point does local activity rise to the level of a claim when you were talking about movement on the ground? Is it one individual, a small NGO? Where does that rise? And I'm sure it's going to be different in different contexts, but if you want, I'm throwing that out there for you. Thank you.
Thanks. Any thoughts in response?
Well, if I take the second part of the question, where does the idea arise? If you look at the literature on this subject about the stages in the process of building a social movement, it usually starts with perhaps one individual, a few individuals who are sufficiently concerned about an issue and adopt different strategies and ways of raising it in the public space. May well be writing to an editor, publishing a pamphlet that is circulated around. If I draw from our own experience in Nigeria in the 90s, we had a military government that pledged that it will respect rights, that it would not put people behind bars and all that. And people were taking in by it. So getting them to move from that feeling that, oh, give it some time, it will address whatever issues you are concerned about, to actually agree that this whole human rights talk was being used as a strategy of gaining time and consolidating itself before unleashing the brutality that eventually happened. Took quite some time. And it was championed by, if you like, social movement organizations, because in this discussion, we also have to recognize the important role social movement organizations play in the process of building a social movement. We understand social movement is not a very organized outfit in the way that you have an NGO, for instance, organized, and or it's not loosely a loose coalition of people as you may have a mass fad, and it's just in between that. But in that informal process of its organizing, there are very organized groups that are driving it. And this is what perhaps makes the difference between those that fail and those that succeed. Because in every society, you do have this phase of mass discontent. If you don't have a social movement organization exploiting those discontent, or what we call in the old era, objective condition, requiring subjective condition, meaning organizations on the ground to exploit this anger and leading it to productiveness. So these groups, which may start as an individual or groups of actually the ones that try to move the populace towards the direction of thinking and reflection they want them. Then at the stage of a coalition, which is when you have succeeded in gathering a number of groups, powerful individuals to identify with the ideas, you could say, using the language of social media, that the whole process has gone viral. So I think it begins with some groups of, some individuals or some groups at the ground to exploit the discontent to advance it. I leave the others to answer the issue of individual rights in non-Western contexts.
So maybe if I can maybe first have a stab at looking at the question of of how, at which point does something local become, sort of something bigger. I think that for me, what's somewhere missing in that is the notion of the vehicles, whether they be organizational or whether they be in relation to media, social media included, the vehicles that exist for civil society to have voice. I think that if you look, for example, at countries in Africa, the places where the opportunities for struggle become most limited are places where civil society organization and civil society voice has been most eroded. And so the notion that because you have a very so if you look at the celebration of Rwanda, for example, by many countries, and particularly places like the United States, for me there's always a question about a country that fails to actually promote and facilitate a multiplicity of civil society voices. And Rwanda is one of those countries that has failed to do that. And I think that now you've got a situation where there is some re-examination of the quality of the growth of thinking and the democracy that's being embraced in that particular country. Because it's not, without that voice, whether you have one person or a whole group of people in one locality, the notion that it will develop into something more in and of its own accord, I think is highly unlikely. The second question that you asked about the question of individual rights and how people in a number of places, maybe in Africa, don't easily relate to that. I'm not sure that how accurate that is in this sense, in that if the notion of individual rights is perceived to be a negation or an undermining of the notion of communal living, communal and collective responsibilities, yes, then the notion of individual rights will be not easily embraced. And I think that there are a number of fairly good reasons for that. I gave you the one example about the individualization of ownership versus the possibility of looking at collective utilization. And so I'm not sure which is more logical and rational. But if you contrast individual rights with group rights, I think you'll get a much clearer understanding from people about the problem of group rights, because group rights are, frankly speaking, problematic wherever they're practiced. So that's the kind of, for me, the sort of way in which what you're putting across, but in terms of asserting the fact that you need protection for individuals and greater protection the more vulnerable they are, I think is something that is not that difficult for people to appreciate if it's not articulated, as I say, in a way that is perceived to be undermining notions of communalism and collective.
We have time for one more question if anyone wants to come forward. We could do two. We could do two questions.
Sure.
Why don't you both present your questions, and then we'll let each panelist have a last word.
I'm a cultural anthropologist, and so I was struck by the question, which I think is a really major question, of how the fight for gender rights is different or similar to other rights. And I think the question of religion, which you allude to in talking about Latin America, but in other places as well, the whole problem when you have an ideology which is so at odds in so many ways, and I'm making huge generalizations, with gender equality presents not unique situations, because you have the same thing with Varna and Jati, caste so-called, but it presents some kinds of problems and issues that make it much more difficult than in some of the other non-gender related rights struggles.
Why don't we get, in addition, Eric, you don't want to ask a question? Yeah. Why don't you throw it up, and then we'll let them discuss both questions as a wrap-up.
So the practitioners on the ground emphasized advocacy for human rights in an Islamic context in northern Nigeria, advocacy for human rights in a customary law context in South Africa. I have two questions. One is, I still don't have a clear interplay, and I've also attended a number of conferences that Janet so eloquently described on where the international discourse on gender equality fits within and somehow supports the local dialogue, which ultimately you are left with a lot of local context and the importance of local content in advocacy. If we could get a clearer situation of the international advocacy of gender equality with the essential local context that must be infused in the proceedings, I think would be helpful. And then I can't resist provoking a little bit on the extent to which courts lead social change, or the extent to which social mobilization must precede court action.
All right. So plenty of food for thought. Why don't we go in reverse order this time, just to be fun, and start with Jim for some concluding thoughts.
I just want to, I guess I'll just touch on the last point. I think there is, it's banal to say, but I do think it's true that there is a continual interplay between courts and the society in which they're situated. And one of our roles, in fact, is to encourage and deepen that dialogue. Sometimes courts get out in front of where broader society is, and sometimes social movements are more successful on the ground and ultimately concretizing things through judicial action. And I'm not sure that there is a universally right way or sequence to proceed. I I think we've seen examples of whole and partial and no success at all with each. But I think it's a continual process, and you need, as we were talking in other discussions this morning, you need both the kind of more informal discourse of society very much to give meaning to anything that courts do. On the other hand, courts and formal law can solidify and powerfully assist and contribute to that discourse or harm it in different ways. So I view it as an interaction that is a continual process.
So I agree with the interaction part of that statement that Jim made. But I have to say, when you sort of spoke about courts leading social change, I kind of thought, no, not in my lifetime. But anyway, I think that there is interaction, but I think that no court action, as much as it can solidify and assist, will actually play a leadership role and will be able to take place in a vacuum of an or a vacuum where there's an absence of social movement to underpin it. And we've got various court cases that the Legal Resources Center has dealt with, which would manifest that quite clearly. So if you take the court case about the antiretroviral treatment that was being denied to South Africans, where we won the action, and it was the victory was a limited victory. The victory was for pregnant and lactating mothers, but it laid the foundation for the entire antiretroviral treatment, and that was because there was social movement underpinning it. If you see what's happening now with our education and text and workbook cases that are happening in South Africa now, again, there's the social movement that's underpinning that momentum. But it doesn't happen all the time where in the absence of a social movement. So I agree on the interplay. The question about the international CEDAW type context and the local struggle, I think is a little different in the sense that I think it also is a bit to do with time and place. But I do feel that there has been a growing gap between the international activism and the sort of formalization of some of those CEDAW processes and action within different countries in terms of mobilizing women. And one of the key examples, which I think manifests that, actually is around the question of reproductive rights. When the issue of reproductive rights was being very, very widely mobilized and popularized, strongly, I think there was a much greater recognition in places, for example, like South Africa, of things like family planning. And it's taken a sort of almost a full circle now for people to recognize that actually to be going on about training people of the dangers of HIV and AIDS and all the rest of it as a replacement for reproductive rights education is in fact one of the major causal factors for teenage pregnancies in schools, as opposed to some of the other mythology that's associated with that. But so for me, that is a very good example of where the international mobilization, there's been a gap, and it's been a gap to the detriment. So, yeah.
Well, I think they have pretty much covered everything. But I think the thing that comes closest to explaining the type of tension, which is, I believe, what you're trying to get at, between the campaigns at the international level and local level, or this whole concept of international human rights movement, is to look at what happens in the criminal justice system. You will think, because it's a system, all the institutions work together towards a common goal. But in practice, sometimes for various reasons, including budgets, they fight one another. So I think that is also, you do have that tension. And the coordination is not as much as you would expect it. But again, it goes to the heart of this whole concept of social movement, because it's often informal, not very much organized. Within it, you have sometimes discordant voices. It could do with better coordination, especially when you are targeting a specific campaign that involve individual. When it's an abstract issue, you can, go to town with all the campaigns materials that you can generate. But where you have individuals at the center of the campaign, it will require much more coordination than we see in the field, to put it mildly.
For saying it. No, the only thing that I would add is in the issue of courts and lawyers and social change is that there has been a lot of literature and debates about capturing the fights and limiting the fights. I tend to believe, because of the work that I do and the things that I've seen through my work, that the law can be really wonderful as an aid for some of these processes of social change, and sometimes it can be a triggering factor. You can call that I wouldn't define it as the court leading the change, but because I think that some of those changes wouldn't happen if you don't have then the mobilization and the infrastructure to follow up on that. But I do believe that legal processes have been and still are interesting parts of campaigns. Some people, the problem is that sometimes lawyers think of that as leading and capturing the process even without understanding what it means to create social change. And so then you have some of the failures of some claims that you have, where you have victories in paper, but then you don't have something really happening domestically. But sometimes even those things, and that's, I wanted to give you my word of support. I think that sometimes even those victories that at some point they seem like just on paper help catalyze process of mobilization and of infrastructure and help ignite social movements and people that then feel empowered by a decision in saying, well, this is my right, and this is, you cannot deport me. I have a right to education, even if you have a whole still very slowly moving process politically of putting those things into place. And so, and this goes to the discussion of to which stage of the process of change should litigation be intersected in. And I don't think it's necessarily at the end of the process or at the beginning.